Late good evening, friends. Let us dive into another case law which has been recently added in the syllabus of Advocate on Record examination. Friends, I am talking about the case law COX and Kings Limited versus SAP India Private Limited, which was decided on 6th December 2023. The bench comprised Honorable Chief Justice D.Y. Chandrachud, Justice Rishikesh Roy, Justice P.S. Narasimha, Justice Jamshed B. Pardibala, and Justice Manoj Mishra. The only two questions were there to be decided by this bench. Can parties who have not signed a contract be made parties to an arbitration concerning that contract? If yes, then under what circumstances can they be made parties? Second one is whether the Group of Companies Doctrine, GoC Doctrine, is valid and applicable in Indian arbitration law. Friends, I am again repeating the question. Can parties who have not signed a contract be made parties to an arbitration concerning that contract? If yes, then under what circumstances can they be made parties? Second issue is whether the Group of Companies Doctrine, that is GoC Doctrine, is valid and applicable in Indian arbitration law. Now let us dive into factual background. In December 2020, the petitioner, COX and Kings Limited, entered into a software licensing agreement with SAP India Private Limited, shortly SAP India. Under the agreement, the petitioner was made a licensee of software which was developed and owned by SAP India. In 2015, while the petitioner was in the process of developing its own e-commerce platform, SAP India recommended its software hybrid solutions to the petitioner. 3 new agreements were entered into by the two companies, one of which was the General Terms and Conditions Agreement containing an arbitration clause. Encountering difficulties in implementing the software, the petitioner sought assistance from SAP SE, the parent company of SAP India based in Germany. However, the project faced setbacks and was eventually terminated by the petitioner in November 2016. The petitioner demanded a refund of rupee 45 crore. In response, SAP India claimed wrongful termination and demanded 17 crore. The petitioner sent notices to initiate arbitration to both SAP India and SAP SC. However, SAP SC was not a signatory to any of the agreements. SAP India did not appoint an arbitrator. Subsequently, the petitioner approached the Supreme Court seeking the appointment of an arbitrator under Section 11 of the Arbitration and Conciliation Act 1996. In short, Arbitration Act 1996. The petitioner contended that SAP SC, by assuming full responsibility for the project, implicitly consented to be bound by the agreement. Moreover, SAP India was entirely owned by SAP SC. This legal concept of incorporating non-signatory into an arbitration agreement is recognized as a group of companies doctrine. Given the importance of legal issue, the three-judge bench of the Supreme Court referred the case to the constitutional bench that was of 5 judges. Now, decision of the Supreme Court. Honorable Supreme Court affirmed the validity of the Group of Companies Doctrine in Indian arbitration law, ruling that companies within a corporate group, even if not explicit signatories to an arbitration agreement, would be bound by the agreement. Regarding exactly when non-signatories may be bound, the court ruled that such determinations should be left to the competence of arbitral tribunals on a case-to-case basis. The judgment of the court was authored by Honorable Chief Justice D.Y. Chandrachud with Honorable Justice P.S. Narasimha authoring a concurring opinion. Now, friends, let us explore reasons for the decision. Non-signatories can be party to an arbitration agreement. The Honorable Supreme Court explained that while the primary approach to identify parties in an arbitration is to look at the signatories to the arbitration agreement, this does not preclude non-signatories from being considered as party to the arbitration. Even parties that have not signed an arbitration agreement can demonstrate their intention and consent to enter into a legal relationship and be bound by the arbitration agreement through other actions. The test lies in assessing whether these non-signatories intended to establish legal relations with the parties of the arbitration agreement. The Honorable Supreme Court held that while a written arbitration agreement is mandatory, the form of recording is irrelevant. Under Section 7 of the Arbitration Act, an agreement is considered in writing when parties formally sign it, when there is documented evidence of their consent, or when an exchange of claims and defense acknowledges its existence. The court clarified that the common goal in these circumstances is to ascertain the parties' mutual intention to be bound by the arbitration agreement. Being a signatory is not necessary. Group of Companies Doctrine applicable in India. Honorable Supreme Court defined group of companies as a set of privately and publicly owned firms in different businesses, even though each firm is an independent legal entity, they all follow a common authority and are linked by trust-based relationships. The GoC doctrine allows a non-signatory company within a group of companies to either benefit from or be bound by an arbitration agreement made by its affiliated companies. This applies when circumstances indicate that all parties, both signatory and non-signatory, intended to be bound by the agreement. The GoC doctrine takes a practical approach, consolidating all closely connected parties in a single form, which is especially used in disputes involving multiple agreements and parties. Furthermore, the court clarified that the existence of a group of companies is a question of fact which courts have to assess. The Supreme Court ruled that the following factors must be considered when applying this doctrine. Firstly, mutual intent of the parties. Secondly, relationship of the non-signatory to the party which is signatory to the agreement, commonality of subject matter, composite nature of transaction, performance of the contract. The Honorable Supreme Court held that to involve a non-signatory, a party must present strong evidence demonstrating the conscious and deliberate participation of the non-signatory. Simply showing that companies work together as a single economic unit is not sufficient. They must actively collaborate on a common project. Furthermore, the court opined that the GoC doctrine exists independently in the Indian arbitration law based on the principle of mutual intent of parties in an agreement. Now, standard of determination by court at referral stage. The Supreme Court explained that Section 8 of the Arbitration Act requires the court to conduct a preliminary check to assess if the arbitration agreement is valid, and Section 11 allows the Supreme Court and High Courts to appoint arbitrators if the parties do not follow the agreed procedure of appointment. The court will decide on the agreement's validity and parties involved in two situations. When a signatory wants to include a non-signatory to the arbitration, and when a non-signatory itself wants to join. However, for complex deals, it is better for arbitral tribunals, not the court, to decide if a non-signatory is really part of the arbitration agreement. This aligns with Section 16 of the Arbitration Act, which allows the tribunal to decide its own authority. That's all. God bless you all. See you again.